Hey guys, good morning, good afternoon. Might even be nighttime near some people, so shout out to you wherever you are. We have this update from Joseph Papp. I've recommended him before. He's a journalist for AGC, but he's also been in the courtroom a lot for the Young Thug trial. And even though all the streams are just waiting with the either looking at the wall, the seal on the wall in the courtroom, or showing their own logo, we do have an update from him that Judge Glanville has taken the bench, so we're probably pretty close to actually having some action. I do also want to point out there's a criminal defense attorney in Georgia who quoted Thugger Daily this morning and said that a couple folks asked me last week if the defense bar would step up for Miss Bumpus, Kayla Bumpus, like it did for Brian Steele. I had no doubt. 6 great lawyers representing 5 separate law firms represent her. I love it. So yesterday when we looked through Kayla Bumpus's motion for Judge Glanville to recuse, and to get rid of that order to show cause against her, we looked at some of the attorney names and they weren't that familiar to me, but it was cool to see a Georgia criminal defense attorney say, I know those guys, they're great, they're awesome, those guys and gals. So I thought I'd share that with you. And we are still staring at a wall on the stream, but as soon as we have some action, we can get right into it. Shout out to Drea, the best mod in the world. Hey Gigi, good to see you. John says, free Thugga. And then, hey Sharon, that's awesome. All the way in Australia. That's probably like a 14-hour plane ride. Oh, we have motion. That's good timing. Look at that. And then, hey Nancy, good morning. And then, hey Angie. Aw, thank you so much. From the UK.
Hi, good morning. We're back on the record in the matter of the state
Let's
of Georgia
go.
versus
Let me make this
Cleef
big.
Adams
You don't
et al.
need to look at me
22
half the
SC
screen.
183572. Let me go ahead and take roll for the morning. Mr. Stillwell and Mr. Sharp, good morning. Mr. Williams, Mr. Steele, Mr. Adams, and Mr. Monsbach, good morning, and Ms. Haltwinger, good morning. All right. Okay, Mr. Kendrick and Ms. Hingerty. How's Mr. Weinstein?
Do you guys want the captions on?
Okay.
Let me know.
All right. Okay. All right. Mr. Huey and Mr. Matthews, Jr. and Senior. Good morning, gentlemen. All right, Mr. Nichols and Mr. Harvey and Ms. Westmoreland, good morning. And Mr. Ryan and Misty Williams, good morning. All right. Mr. Atkins and Ms. Hilton and Ms. Knight, good morning. All right. I missed anybody? Okay, all right. Okay. First order of business the court needs to take up this morning. I have 2 motions to recuse, one filed by defendant Jeffrey Williams that was filed yesterday and handed to the court at the end of the business day. Another one has been filed under the same indictment, this indictment 22 SC 183572. And I want to say that motion to recuse has been filed on behalf of Miss Kayla Bumpus. Can I get the lawyers for, or the principal lawyer for that particular case to identify themselves for purpose of the record?
Judge, good morning, Gabe Banks.
Good morning, Mr. Banks.
Her legal team is also here. Mr. Collins, Mr. Novey, Mr. Mormon, and Mr. Winchester.
All right, good morning, counsels.
Got the whole gang.
As it pertains to your motion, Mr. Banks, and on behalf of everyone that is here, I'm going to just take up the issue of the recusal. I'm going to defer the issue of the motion to quash at this point in time, okay? So I'm not going to take up anything. I can't do it anyways because the rules require me to go ahead and deal with the motion to recuse to begin with. So I've ceased any other business, and that's why I had Mr. Chamberlain reach out to you last night and counsels for you all to be here this morning so I could take this up. Your motion actually was filed last Friday at 10:40 p.m. It didn't appear in the system, however, as sometimes Odyssey happens, until sometime on Monday evening. So When I started to read Mr. Steele's affidavit last
That
night,
actually
we were put
seems
on notice
consistent,
that there
guys,
was
that it
possibly
didn't
another
appear.
affidavit out there and another motion. So that's why we had to call you, okay? So that's how we got here with this. Or else, did you all attempt to send me independently another, a copy of that, or?
We did not, Judge. I don't.
Okay, no harm, no foul, no. So, no, I just wanted to know if you had attempted to do so, because we would have certainly, had we known that, pulled you in on Monday morning, which would have been the closest time that I could have heard your particular motion. So just from a time aspect, I just wanted to account for that. Taking a look at and this applies to both motions that have been filed to recuse the court or disqualify the court. Recusal by a Superior Court judge is governed by Uniform Superior Court Rule 25, etc. Rule 25.1 provides that all motions to recuse and disqualify a judge presiding a particular case or proceeding shall be timely filed in writing, and all evidence thereon shall be presented by accompanying affidavits, which shall set fully assert the facts upon which the motion is founded. Filing and presentation to the judge shall not be later than 5 days after the affiant first learned of the alleged grounds for the disqualification, and not later than 10 days prior to a hearing or trial, which is the subject of the recusal or disqualification, unless good cause be shown for the failure to meet such time requirements. And that is cited in Georgia Uniform Superior Court Rule 25.1. So I'm applying that to both sets of motions to recuse. And applying this rule, Georgia courts have held that when a motion to recuse is filed, the trial judge shall immediately, 1, determine the timeliness of the motion, 2, the legal sufficiency of the affidavit,
What do you
and
think,
3, the legal
guys?
sufficiency of the grounds, and has no power to do anything else. And that is Robinson versus the state, 332 Georgia Appeals at 242-41. The 3 threshold determinations that the trial judge must make in regard to a motion to recuse are whether it's timely filed, whether the affidavit made in support is legally sufficient, and whether some or all the facts set forth in the affidavit are true, recusal would be warranted. And that is Dacker versus the state, 300 Georgia, 74-77, 2016. The judge finds any 3 of the conditions have been met. No, I'm sorry, take that back, strike that. If the judge finds that all 3 conditions have been met, he must refer the motion to another judge to hear the motion. But if any one of the conditions is not met, there is no error in denying the motion. And motions to recuse are viewed and considered by the appellate court for abuse of discretion. Accordingly, the court's going to address each one of the factors as it pertains to both Mr. Steele's motion and, for shortness, Mr. Banks' motion. I find both motions were timely filed. I find that Mr. Steele's motion was in fact filed on this past Monday.
Judge doesn't know what day it is. Me
Which would
too.
have been the 17th of June. I find that Mr. Banks' motion on behalf of Ms. Bumpus was timely filed, as it was filed on the
Friday.
filed on the 14th of June at 10:40 p.m. Secondly, I find that in addressing the legal sufficiency of the affidavit, that means, was it sworn? Was it sworn before a notary? Is in proper form? I find Mr. Williams and Ms. Bumpus's motions to be, I should say, affidavits to be in proper form. The third thing that the court has to review, and like I said, I reviewed, is the legal sufficiency of your grounds of the motion. And And here's where the court finds that upon a review of Mr. Steele's motion and affidavit, as well as Mr. Banks' motion and affidavit, that both contain assertions
Sufficiency of the evidence is supposed to be a prima facie consideration
bare
on its face,
assertions
except
and
that it's
legal
true.
conclusions which aren't sufficient for the court to grant your motion at this point in time and refer it to another judge for it to be heard. So I'm going to deny the motion at this point in time. I invite you all to look at Baptiste versus the state. Just because adverse rulings have been made doesn't mean that the court stops the trial. So I'm going to make that. I'll reduce both of the motions to recuse to an order, and I will file that so you can take whatever steps you need to necessarily after that. But I don't get into anything about the affidavit itself, argument on that. I just have to read it. Those are the only three things I do. And then if I find it to be not sufficient on its face, I go for it. I just make the ruling at that point in time, let you all take it up. No, I won't grant a motion for a certificate for immediate review. And that's where we are at this point in time. Anything else, Mr. Banks?
If I could just briefly be heard, Judge.
Sure.
I'm excited to see a new attorney arguing.
I'm not trying to,
This is Dave Banks.
I understand the court's ruling and we'll proceed as we see fit. I do take issue with the court's characterization about the legal insufficiency of the affidavits.
Well, that's why when it was reviewed on appeal,
Sure.
it can certainly be, I mean, the appellate court will review my ruling for abuse of discretion.
Certainly
Okay.
understand that, Judge. And in stating that, Judge, I would just say that one of the issues that is raised in our affidavit, because our motion to recuse is to recuse you from the contempt proceeding, not the underlying criminal case in which Your Honor is presiding. And so we really don't have an issue or standing to even challenge that. And so to the extent that there is a contempt proceeding that is set for the 25th, Your Honor, you are a witness to that proceeding. And so because you were a witness.
I don't believe you. I'm not going to get into any argument, but I can't. So that's your assertion at this point in time. And like I said, when that is taken up, I'll consider it. I also remember, I still need to rule on the issue of the motion to quash. So I may, depending upon what I decide to do at that point in time, other things may be ripe. Okay.
Do you want to hear about the motion to quash, or you want to take?
No, not yet, sir. I'm going to take up the motion to quash after I finish. We finish the direct of the current witness.
Okay.
And to other issues that have been raised, as I've told some of the other lawyers here, there is a transcript of what occurred in the ex parte matter. I will, in fact, I'll authorize defense counsel. I'll do a privilege review and see what needs to be disclosed in terms of impeachment and/or Brady, and for that, and I will do that. And then so if that pertains, or if that issue affects you, then certainly that may be something that at the appropriate time you'll be able to have a look at.
Well, I appreciate the court's time. We would certainly rely upon our brief and our motion, and that's a part of the record. Okay.
All right. But I will reach out. The court will reach out to you on two things. One, the ability to take a look at the ex parte transcript and review it for the appropriate parts that the court will authorize. And then also for the, I'll re-notice you, because I know that it's supposed to be done this Tuesday, but but I doubt that we'll probably have it this coming Tuesday.
If I just may say, again, Judge, I know I've already said it as it concerns the issue about you being a witness to the proceeding. We don't believe that that's a bare allegation. We believe that would be an established fact at the hearing. We also.
But I can't take it. It's not something that I can argue with you at this point in time.
Let him make the record.
I'm not trying to argue.
No, sir. You are an advocate for your client. Sure. That's the only thing I can say, but I'm not going to take up that issue right now. It's part and parcel. You made it part and parcel of the motion to recuse. So I'm saying that at this point in time, I've made my ruling. You've said what you need to say in terms of what your thoughts are. I'm going to reduce it to an order, and you can take what you want to after that. Okay.
All right. Thank you.
All right. Thank you, sir. All right.
So he made a good distinction when he got up there and said,
Mr. Steele,
our recusal is for the contempt hearing, the order to show cause hearing, where you're threatening to hold Kayla in contempt.
We'll be able to take it up as you see fit. I'm not going to grant a motion to a certificate of immediate review. Anything else?
Let's go.
I have read Baptiste versus State. I've read
of course
all the
he did.
cases, that I believe are applicable. I'm, best I can. But specifically, if the court would reconsider, and if nothing else, the Honorable Keith Adams and my joint affidavit in paragraph 12, we assert not a bare assertion or a legal conclusion, but we make facts that we specifically adopt from the Honorable Attorney Winchester, Collins, Banks, Nove, and Mormon's
Kayla's affidavit,
where a person that they represent was in a meeting ex parte with the court and others, and the prosecutor and a witness, and specifically they wrote in a pleading and under Parrish, which is P-A-R-R-I-S-H versus State, which is 362 Georgia Appeal, 392 Division 1, 2022, the lawyer's pleading on behalf of the client becomes a statement of the client. And they said that this court got involved with speaking with Mr. Copeland and assisted in Mr. Copeland testifying against Mr. Williams. So I've added this court to the witness list. I plan on calling the court as a witness in the trial. I added lawyers Hilton and Love from the district attorney's office to the witness list. And when I cross-examine Mr. Copeland, when that day comes, I'm going to ask him about how much pressure, if any, the court put on him. And you're going to be the one instructing the jury. And I just can't imagine how that's fair to Mr. Williams. So I just asked you, I'm not abandoning anything in the joint affidavit from the Honorable Attorney Adams and myself, but if you would just look at just even paragraph 12, again, if you didn't consume it entirely, I don't believe that meets a legal conclusion or a bare assertion. I asked the court to recuse.
I've read your affidavit, Mr. Steele, and I've consumed everything on it, and that doesn't change my ruling at this point in time, respectfully.
I also, on the transcript, I'd like the recordings and the transcript, and I object to the court going through it and deleting, because to me, the way I understand it, there is zero privilege. So I don't understand
I'm not gonna, Mr. Steele, I can't argue with you about anything such as I've made my ruling, okay? If you have some other basis to ask for the recordings or anything like that, you're gonna have to put those in some other pleading. But at this point, Ms. Weaver is gonna prepare the record. She does that. And like I said earlier, the record should be ready soon.
He's gonna prepare the record, but he said he's gonna look through it.
Group will have the opportunity to take a look at that particular ex parte transcript that was done in chambers. Less
See,
anything
eating
that
into the mic.
is totally, that the court considers to be privileged. And I'm gonna let you do that before you examine Mr. Copeland. So you'll have everything that you have at that point in time.
Thank you.
All right? Okay. All right. Let's turn now to the statements or interviews from January.
Not to interrupt the court, that finishes our business today, man.
You don't want to stick around?
No.
Okay. Well, okay. Thank you, Mr. Banks. At all. Okay. All right. Okay. Yes, you may be excused, sir.
So I just want to make sure that they're going to actually go into the interview stuff with no one else saying, hold on, wait, I need to make a record. But I do have it set up to, I'm going to link you to other channels that are covering these arguments about this evidence and what parts of these interview videos can come in. I wanted to focus on this. Of course, we knew Judge Glanville was going to deny, but...
and counsels, what matters do you have to take up from the interview from the the January 28th, 2015 interview?
Your Honor, last night we sent over both the February 21st and January 28th redactions. We sent the February 21st one around 7 p.m. and then the January 28th probably around 11.
All right, so it looks like they're going to go into those. I do have this set up to redirect you into Nick Staro's stream, and I'm going to link the lead attorney because they're both streaming the day of motion. So if you guys want to watch the arguments about what clips of these interview videos can come in, that's where I would say go watch it. I'm not going to tune into that. I'll tune in and watch what's actually decidedly played in court in front of the jury when the jury's back on Thursday. Their court's closed tomorrow. But some of what you guys are pointing out, Weaver's listening. So Trey here's talking about Weaver listening, and I thought it was really interesting that Judge Glanville, after he repeated 3 or 4 times while Dave was on the stand speaking for Caleb Bumpus, the judge was like, after the court reviews the transcripts, you'll get the parts. After the court reviews the transcripts, you'll get whatever parts are not privileged. But then in this last part, he suddenly changes. He doesn't keep repeating that over and over. He's just like, well, Miss Weaver's going to go through it. And to me, that's kind of like, Miss Weaver seems likable. She's been the subject of a sort of meme going on with Woody and the Chuck Taylor, what color her shoes were. But in an endearing way, right? It's not a meme where people are laughing at her. It's a meme where people are like, oh, she's nice for that. And it seems like when he said, well, Miss Weaver is going to prepare the transcript for you, he was kind of trying to adopt the credibility we would expect Miss Weaver to have. But just because she's the one preparing the transcript doesn't mean the end product and the parts that are piecemealed up to be delivered to the defense counsel still has the same level of integrity as when Miss Weaver actually prepares it. So I think it was like really, I think it was a little irritating that he kind of caught himself and tried to lean on Miss Weaver for the integrity of what he was going to produce. That really bothered me. Cause shout out to court reporters in general, but especially Miss Weaver. I mean, she's been at this for this trial for like, I think she's been doing the pretrial stuff too. So for more than a year. And then what do we got going on? You guys all predicted that he was going to deny this. I was surprised he even said point 2 was met. And I'm not surprised that Steele got right up on the stand and said, I've read that same case that you're citing, Baptiste. So I'm not surprised that he was prepared. And then, yeah, him eating in the mic, coughing in the mic, and sneezing directly into the mic. Like, at one point when he sneezed, if you guys were watching the screen when he sneezed, it looks like he was sitting like this and knew he had to sneeze, and he looked, my mic is right over here. It looked like he went like this when it was time to sneeze. Right into the microphone. Like, what are you doing? And then he's chewing this candy, and, you know, I get that there's sickness going around, though. I'm wondering if it's possible ADA Love has COVID or had symptoms of COVID, so she stayed home, because Doug Weinstein tested positive. He has COVID right now. But, you know, usually when you test positive for something, you have the symptoms. He was already sick in court. He had the mask on. The stuff was in the air already. So who knows? I don't know exactly why ADA Love is not there, or Chief Deputy DA Love is not there today and wasn't there yesterday. And it's kind of weird that she's not, because sometimes ADA Hilton seems a little bit more jumbled trying to get the paperwork and the stuff at the desk together. And she's going to have to argue now all these timestamps from these videos. So, okay, so Love is actually there. Weird. So I wonder, maybe she's just sitting somewhere else, because even the table right behind them, I only saw one person sitting at it. There were extra seats there today. Oh, so the Adidas sweater. So it's got these 3 yellow stripes, and it's got the logo all the way down. It might say Sabiba. I don't know if my camera's reflected mirror image on the stream. But I've had this a long time. It's like, that's why it's a little loose in the collar. But I've always loved it. I get cold in the mornings. I live in Florida, but with the AC pumping until the day gets going, I'm always cold in the morning. So I still wear sweaters all the way down in Florida. And then, yeah, that's why everyone had all the masks yesterday, and now they don't have them. But yeah. So, and then, yeah, so I've noticed, with Woody giving the looks, like, honestly, he's toying with the people in that room, and, you know, I kind of wonder, I want to wonder what ADA Hilton thinks of Woody's intelligence. I really get the impression that she doesn't think he has, you know, anything close to average, let alone above average intelligence, because maybe the way he speaks, his accent's really heavy, he uses slang, but to me, he's sharp. And I know some people have a hard time understanding the terms that he uses to make his point, but I know for a fact ADA Hilton did not understand what Woody was saying when he said, well, look, if I say that the court reporter's shoes are white, I'm doing that to tell a small truth, so anything else I say is easier to believe. They'll believe that I'm telling them the truth, they'll accept what I'm telling them, and they'll let me get up out of there. But ADA Hilton's response to that was, but they are white. Yes, exactly. The point is that I find things that are obviously true to bolster my credibility. So that way I can, you know, build the rapport for the detectives to buy the rest of the stuff I'm about to sell them. And ADA Hilton in that moment did not get it. Like, she really didn't get it. And I've noticed the same thing throughout a few different lines of questioning in her direct examination with Woody. I also thought it was interesting, speaking of the direct examination, we know that's going to extend a few more days because court's closed tomorrow. I believe there's also no court on Friday. And then, so that's one more day. So unless they clip the rest of these interviews down and get through direct on Thursday, direct is going to extend into next week. Well, what's next week? Tuesday next week is supposed to be the order to show cause hearing. And that was scheduled for 9:30 a.m. in the morning. So really first thing. I doubt that they'd come have 30 minutes of movement and, all right, we're just going to switch over to the show cause hearing. It sounds like a first matter to address on Tuesday morning. Judge Glanville said, we're not going to turn over these transcripts to you until after direct examination of Kenneth Copeland is done. Do you guys think direct is going to be done on Monday next week with the rate that we're going at? What do you guys think? It seems like he said direct to make it seem like he had a basis to delay handing over the transcripts. But to me, it's arbitrary. If you're worried about protecting the witness in some way, or protecting the integrity of his testimony because you need to keep the sanctity of what happened in this ex parte meeting and this agreement, you know, somewhat concealed through his testimony, it doesn't make sense that you would use direct as the breaking point. Why wouldn't you want that to also apply during cross-examination and rebuttal? I think he's just trying to address Steele's concern that he won't be able to properly cross-examine witness Woody, but he's going to be like, oh no, for Kayla, this order to show cause hearing, it just happened faster than we can get through direct. It's like he's trying to toy with the court calendar, acting like he's going to do the right thing to give Steele what he wants before cross-examination, knowing that it's not going to play out that way. That's my personal opinion, my personal break on that. You guys may or may not agree. And then, let's see. Hold on, I don't know did I refer to someone? Is this a response to something I said? He can't even explain what he's trying to say. She didn't get it because he didn't say anything coherent. No, he really did. If you go and watch that clip with the court reporter when he was saying, if I say what color her shoes are, they're white, right? They're Chucks. he was trying to tell Hilton that he tells the truth sometimes. And Hilton just thought, yeah, well, her shoes really are white. That's the truth. That's not a lie then. He wasn't trying to say that he was trying to come up with a lie to tell. He was trying to say, I'm going to find the easiest thing to talk about as a way to open the door for the rest of what I want to say. And yeah, like it went way over Hilton's head. And he just stared at her in that moment. So I'm not saying he's like, you know, what do they call it? Like a Mensa? Is that, you know, you got like the 185 plus, I don't know the exact criteria, IQ. But I'm saying, like, I think Hilton approached this witness as someone who's just adult. And he may have been privier than she expected him to be during this ex parte meeting. Before they were even in there. Yeah, I really think, like, Woody, in a way, is playing them. And yeah, so just my opinion, this is the wildest judge I've ever seen. I'll adopt that a little bit. There's some others, like there's like a recent story where a judge was like assaulting people, like assaulted like 3 different people in a road rage incident. So that's a little bit wild too. but you know. And then, I mean, last time he ran unopposed. So we'll have to see if someone actually runs against him. So not really sure on that. There is the judicial conduct, the Judicial Qualifications Board is what it's called in Georgia. They have monthly agenda meetings and they let the public come in and speak. I'm not a Georgia resident, I live in Florida, but that's June 21st. So I do wonder if anyone's going to go to that meeting and speak publicly and say, hey, we have concerns about what's going on in Judge Glanville's courtroom and the specific trial. So as far as his election, someone's got to run against him if he's going to run again. But yeah. Yes, so I'm probably not explaining it correctly. So Patrick, Woody was also saying he lied in the interviews. But he was saying he told them, if this whole circle, like my 10 fingers, or everything he said in those police interviews, he was like, well, when I first get in there, we'll just use my thumbs as the example. I try to find little things that are easy to speak the truth on. That's why if they ask me what color the sky is, I'm going to say it's blue. If they ask me what color her shoes are, I'm going to say they're white because they're actually white. I'm going to tell this little bit of truth. That way they're like, okay, well, he's competent. He's truthful. He's not trying to play us. That way when he says these other things, they're less skeptical of him. So he's saying, yes, I lied during those interviews, but I set it up so it would seem believable and credible. That's what he's explaining in his testimony over the last week. But he absolutely did say he lied during those interviews as well. And this is a great way to, this is much better of an explanation. Thanks, Drea. So Woody's saying he mixes truth with lies. Truth because she's wearing white chucks. Lies that she was sitting outside. And then can Woody be compelled to answer questions of the ex parte during cross? I mean, to compel him, it would be it seems like the remedy here to compel him to answer would be putting him back in jail, holding him in contempt. And I don't really know, the judge could still decide to do that either way, but I don't know necessarily that the defense will request that. I'm actually interested in seeing the demeanor of Woody on cross-examination, particularly because there's multiple co-defendants, and like Shannon Stillwell's attorney is Max Shart. Young Thug's attorney is, as we all know, Brian Steele. And I'm curious if his demeanor will be across the board completely different on cross-examination than his demeanor is when he's dealing with ADA Hilton on direct examination. I'm also wondering if, how hard Max Shart is going to come at Woody, because Shannon Stillwell is his client, right? That's the one that's really like in the hot seat about this murder of Nutt. And then maybe he'll be different with some of the other defense attorneys who get up there. I can't really guess until I see it play out. But I would imagine, I can't really imagine the defense wanting to, judge, hold him in contempt so he answers, when they kind of already have it right in front of them, the inconsistencies. Well, you were offered a deal. Did someone tell you they won't prosecute you if you lie on the stand? Did someone tell you? Saying that question is enough to say that in front of a jury. Even if Woody doesn't want to answer that question, the question still gets out there. And I guarantee you this will be some of the most, say we end, let's just pick a day, Wednesday next week, say direct examination ends on Wednesday. They either take a lunch or they do it at the end of the day. It's fresh. The jury's seated fresh when someone like Brian Steele gets right up there and comes out with his first question like, now, did you have a meeting with the prosecutors and the judge on Monday of last week? The jury's going to be sharp and paying attention because we've just switched away from the prosecution asking the questions, and now we have this fiery lightning. They're all tuned in, and these questions launch right away about this secret meeting. The jury's going to hear the questions even if there's no answer. So I don't think they need to request the court to hold him in contempt if he doesn't want to answer something. I think they'll know how to use that to their advantage, although we'll see it play out as it goes. I would actually totally watch the first day of cross-examination of Woody. I think that'll be really interesting. And that's the thing, KR. So he's not a credible witness, right? And it's the state that's putting him on. It's the state that really needs key testimony from him, one, to help prove their case, but two, to also lay foundation for other things they want to bring into this trial. So he's important for what they need to move forward to prove their case during their case in chief. But since he's not really credible, I think the defense is already starting at a complete advantage with him, even if Woody doesn't want to answer their questions either. It's just going to be in their favor. And I think we're sitting here on the outside, but we're regular people too. I imagine at least some people on the jury are thinking exactly the same thing. Well, this guy's not credible. How do I know what to believe from him? So sometimes the things that we discuss in here could be exactly what's going through the jurors' minds. Yeah, he's just there and everybody's trying to pull his strings. And then Sally Ann says, was it reasonable to expect the jurors to use their vast knowledge of body language to determine whether Woody is lying or telling the truth in the police videos? Now, so the jury is allowed to look at demeanor and decide if they think, it shows intent. They're able to look at body cues, tone of voice, and judge it how they want to judge it. But I don't know, that audio, I think it was hard to listen to. I think if you're tuning out, and I don't know exactly how big the screens are, I imagine that the jurors probably have additional monitors, kind of like the one that's sitting in front of 88 Hilton right here, that are closer to them. But it wasn't great quality video. And if you're zoning out, you may or may not be tuning into, maybe he swings his arm like this in a moment. Maybe you'll notice that because it's obvious. But I don't think you can really see facial expressions in the quality of that video. So it's hard to say that even if they were trying to look for that stuff, how much would actually be apparent. So, unless it was an exaggerated movement. But they can, and they're allowed to look at things like that, look at the demeanor. And then, yeah, that's the thing too, Leah, is that the state always knew he wasn't credible. And it's not clear if the jury is aware of that. Maybe they've kind of guessed that on their own. But that's when, with cross-examination, with this questioning of the ex parte meeting, even if the questions aren't answered, the defense can say, and the prosecution knew that you didn't want to testify. And the prosecution offered you a deal so that you would testify. And then the prosecution said if you don't answer their questions, they would not prosecute you. Or if it was this question, that they would prosecute you. So even if those are objected to and sustained, or Woody's just like, I don't know, I don't recall, the questions still come out there. And it's going to be delivered. I can't imagine Brian Steele or even Max Shart asking these questions in a way that's going to be low energy or boring, where the jury is going to be yawning and tuning out. And then, so they're going to continue to try to move this up through like the Supreme Court, but the issue is they have to do something like a writ of mandamus, something, hey, we need you to order this court to do something because they're not willing to do it themselves. But that could take time because the judge isn't issuing a certificate of immediate review, which would basically be a ticket to take to a higher court, a Supreme Court of Georgia, and say, look, this judge needs you to review this for us. Here's my certificate of immediate review. Now they have to go and petition for a writ of mandamus, ask the court, hey, this is what's going on down here. We need you to step in. Will you please step in? Here's our basis and our argument for you to come step in. And that just, court calendar, it's just going to take time. So I'm sure there's so much moving right now, even that we're not seeing, probably from multiple parties. So we know Doug Weinstein filed a motion to recuse, Brian Steele has, and then Kayla Bumpus has, even though it's just for the order to show cause hearing. She still filed a motion to recuse Judge Glanville from that action, that proceeding. So all of that's there's moving parts. We see that 5 attorneys showed up for Bumpus. Steele has like a whole army, the Strike Force, the Georgia Association of Criminal Defense Lawyers, on his behalf, working through his appeal with the Supreme Court of Georgia. You know, there's just so many moving parts. I don't know about taking it to a federal level unless, you know, I'm not saying that that's not possible, but I think the channel here is the Georgia Supreme Court. And then, Antoine, we're not going to get this answer. Why won't he give the defense the whole transcript of the meeting? That's crazy as hell. He's hiding something that he doesn't want to come out. Probably. And he'll probably lean on some argument where there is a little bit of discretion, where he can say, you know, there is some basis for me to redact certain things. But the problem with that is it's almost like looking for Sasquatch. It's looking for a Yeti. In that case, the best the defense counsels can do is say, we don't know what was there for sure because he was the one that reviewed he filtered his own content, his own transcript, as a party that you cannot say is impartial before he provided it to us. But we can't actually say what was removed from it unless, you know, someone else that was in that hearing or the court reporter comes forward and say, hey, this was filtered out and it shouldn't have been filtered out, and I think you guys need to know about this thing specifically. So it's creating a mess, and I think there's a gray area where he's going to try to leverage that gray area to withhold certain things from those transcripts, but it's going to be hard to completely call him out on it. They can say, hey, we think you may have over-filtered this. How can we trust you to filter this properly? But how do they also prove something specific was redacted from that transcript that shouldn't have been if they don't actually have the original, right? So it's just rock in a hard place. They're sticking him there. And then let's round this up, guys. So I have this set to redirect to YSL Trial Watch. I'm going to drop both of the links to, we'll do the lead attorney. I'll do that as the first link if you want to go over and watch. I think AV to the 7th Power is also co-hosting today. But if you want to watch the full, this debate on these police interviews and what parts can come into play in front of the jury when they're back on Thursday, there's that. And then I'm also going to link over to YSL Trial Watch. Now with YSL, he's been covering this case from gavel to gavel. So the second link here is YSL's channel. That's where this video will automatically redirect when I end the stream. Please hit the like button on the way out. If you guys, as closing thoughts, if you have another channel that you like to stream this trial with in full, the full days of testimony, leave it in the chat or in the comments. You can shout out whatever channel you like. I'm totally fine with it. Those are just the 2 I'm aware of that are streaming right now that aren't just like Law and Crime or Fox Atlanta. So, and then hey Chip, good to see you. I know it's been crazy in here, but I love the chats. But other than that, you guys, when this ends, I think it'll take you right to YSL. I'll probably hop back and forth between both chats. So see you over there if you follow along. Take care until next time.